Moderating today's session. I am a law professor at Howard University, where I've been teaching for the last 30 years. I'm also an arbitrator and a mediator. I'm the immediate past president of the National Academy of Arbitrators. And I'm going to use the mic for a moment to share some very good news. I also chair something called the Ray Corollary Initiative Incorporated. It is a nonprofit corporation, the mission of which is to increase diversity in the selection of arbitrators, mediators, and other ADR neutrals. It has just been announced publicly today that the AAA ICDR Foundation and the JAMS Foundation have funded the RCI in a three-year grant, $250,000 each year. These are the two most prominent appointing entities for arbitrators and mediators in the United States. And they are also pledged to commit themselves to assisting the RCI in the increase in diversity in arbitration. So I'm very happy to share that. We have a very stellar panel today. I'm going to use a short intro to introduce each one, and we're going to permit questions during the course of the presentation, with the understanding that I may have to cut off discussion or questions so that we can move on and cover all of the material. But we do invite you to ask questions that come up when each of the presenters is commenting on a scenario or a problem. And we will leave time at the end for questions as well. To my immediate right is Marlene Gold. She is a graduate of Boston College Law School, and she began her labor relations career working for the city of New York. She first worked at the New York City Sanitation Department, where she was chief counsel and deputy commissioner for legal affairs. She then moved on to be first deputy commissioner of the New York City Fire Department, and then as first deputy commissioner of the mayor's office of labor relations. Ms. Gold began her public service as a neutral when she joined the New York City Office of Collective Bargaining in 1995. She served by joint appointment of the mayor and municipal unions as the chair of the tripartite body adjudicating labor disputes between municipal unions and the city. Ms. Gold enjoys, and I'll be calling her Marlene. We've known one another for a long time. She enjoys a national practice in a wide variety of industries that include public school systems, higher education, airlines, utilities, telecommunications, and entertainment. Marlene is a member of the National Academy of Arbitrators. To her immediate left is Mark Gaston Pierce. Mark is a member of the National Academy of Arbitrators and is a fellow in the College of Labor and Employment Lawyers, where he serves on its board of governors. He is also a visiting professor and executive director of the Georgetown University Law Center, Workers' Rights Institute. Prior to joining the faculty at Georgetown, Mark taught at Cornell School of Industrial and Labor Relations. He is a graduate of Cornell University and University of Buffalo Law School, and Mark co-founded the Buffalo, New York labor law firm of Creighton, Pierce, Johnson, and Garreau. Mark served as a two-term board member and twice designated chairman of the National Labor Relations Board. Prior to that, he was board member of the New York State Industrial Board of Appeals. Mark now serves as a presidential appointee to the Federal Service Impasse Panel of the Federal Labor Relations Authority. He is also an accomplished oil painter who is exhibited in several cities. If you have not had the opportunity to view his work, I highly recommend it to you. It's spectacular. Katie Rosen will be a member of the National Academy of Arbitrators soon. Katie is a labor arbitrator and a mediator. She is based in Connecticut with 15 years of collective bargaining and grievance experience in the healthcare, public safety and transportation industries, and in both the public and private sectors. She's been a neutral for 1 year and is on the permanent arbitration panel for the state of Connecticut and the Connecticut Employees Union Independent. She is also currently enrolled in the Labor Arbitrator Development Program at the Scheinman Institute on Conflict Resolution. We are going to move to the program, and I want to say on behalf of all of the speakers, they are speaking for themselves, and they are not giving legal advice. As lawyers, we are always conscious of making that disclaimer. What we want to do today is not go to the forest, if you will, as the earlier panel did about arbitration issues, but rather we're going to dig a little deeper into the weeds and talk about tips. Some tips then. Be careful about over-promising. What you're telling the arbitrator is what you ought to be proving. You want to lay out the legal argument. Usually it's the collective bargaining provision that is applicable. You want to make that clear. And one of the things that new advocates often do is that they'll refer to the collective bargaining agreement, refer to a particular provision, and rush right past it, not giving the arbitrator an opportunity to look at it. Slow it down, take your time. This is your arbitration. Having said that, you also want to avoid too much detail. You want to give the arbitrator a roadmap. What is the arbitrator going to hear from you? What is the arbitrator likely to hear from the other side? So that the arbitrator then is equipped to be able to make rulings during the case. Next, do you defer? I have a very strong sentiment about this. You may have a good reason to defer. And usually it's the union that defers making an opening statement. That should be very unusual, that you don't make an opening statement. And why? You want to make the opening statement so that the arbitrator knows what your case is going to be while the arbitrator is also hearing the other side's case. You want the arbitrator to know on what basis the arbitrator should be making evidentiary rulings. Can't do that if I haven't heard anything from the union about the case. So, what you want to do is make the your opening argument begins with the theory of the case. You begin to formulate that theory as soon as the case file hits your desk. It may only be one sentence initially, and then it begins to evolve. That theory of the case also becomes your investigation vehicle, identifying evidence, both witnesses and documents that you're going to want to pursue. And then you'll begin to know what are the weaknesses and what are the strengths in your case. Again, what are the weaknesses and strengths in the other side's case as well. That is equally important for you to point out. Now I'm going to turn to issues of arbitrability and turn to our panel. We've developed a number of hypotheticals and scenarios, and each panelist is going to comment, and others may offer some additional comment on that. So we're going to start with Marlene.
Homer, before you go to the next slide, can I ask you a question on what you said?
Certainly.
What happens if a party says, I'd like to defer? Is it usual or unusual for the arbitrator to say, no, you can't defer, I want to hear it now?
I would like to. Those who appear before me know that I consider myself sitting at the right hand of God, and therefore I can do anything. But I will not do that. No. If the party decides to defer, I will not force the party to make their opening statement. I will caution.
I have made it.
I just Just wanted to add, all of these slides are available on the app. So if you look at the panel date and time, it's a PDF in there, so you'll have these later.
Okay, thank you. So, has everyone had a chance to take a look? I'm sorry, this light's a little blinding, so I can't tell from your faces, but I'm assuming you read it. Okay, so let me start by saying that this is kind of an interesting, can y'all hear me? Yeah. This is kind of an interesting hypo because it's not your traditional challenge to arbitrability. So there's a single purpose, right? A single goal when management, usually management, challenges arbitrability. And that goal is to stop the arbitration from taking place. And how do they do that? They either allege a violation of procedural arbitrability or substantive arbitrability. And what is the difference? Procedural arbitrability usually says, hey, we can't proceed to arbitration in this time frame because you violated the time frame for filing. If your collective bargaining agreement may say you have to file at step 1 in so many days, step 2, step 3, you have to file your demand for arbitration. You violated that, the matter's not arbitrable. That's considered a challenge to arbitrability, that's procedural. Another kind of procedural arbitrability might be where the contract says you have to state with specificity what provision of the contract is violated, and then the grievance says, I was treated unfairly during December 2023, and this violated a variety of provisions in the contract. Beep. So they will say, no, that's not the specificity we need. It is a violation. It's a question of procedural arbitrability. Moving on to substantive arbitrability, right? That simply means, right, that the person who is challenging the request to go to arbitration is saying that this subject matter is prohibited as a matter of arbitration. Usually that occurs by statute or by a judicially articulated public policy. Perfect example for you folks would be the decision to grant or not grant tenure, right? That's reserved to the university, either in some states explicitly by law, in others by court decision. So those challenges are designed to have you not be able to get to arbitration. This case is a little different because the union wants to go to arbitration, but they're asserting a violation of this time frame so that they can prevail even before they get to the merits, right? They're saying it's two-pronged here, right? The union's going to say, one, these charges, this disciplinary action was untimely based on the contract, but even if you find it warrants, there's no just cause for the disciplinary action. So absolutely, is there questions? I don't know if 16's up there, you want to, okay, good. So absolutely, you would mention this in your grievance. You would say the disciplinary action cannot stand because it was taken in violation of whatever provision sets out that 10-day rule. Was it a 10-day rule as hypothetical? And then you will say, in the alternative, if it was timely, there's not just cause, right? And you want to be able to pursue both of those. Now, for those of you who are advocates, if you're the union's advocate and you realize this now, but it hasn't been brought up, should that stop you from raising it at arbitration? Anybody thinks it should stop you? Good, because it shouldn't stop you. It's up to the arbitrator to say no. You forge right ahead. And your argument should be, if the other side says, hey, well, you should have mentioned this during the grievance process, you would go back, the union would be expected to say, hey guys, you bargained for this 10 days. You put it right in the contract, it's express language in the contract, you shouldn't be surprised in any way that it's being raised. You signed on to this.
Arlene, one last question. Let's assume the arbitrability question is raised, and usually it will be the employer, but not always, requests the bifurcation of the issue. That is to say, Madam Arbitrator, we want you to hear and decide the arbitrability issue and not proceed to the merits until you've decided that. How do you handle that?
Okay. I don't know about you folks. I'm not a fan. Okay? Here's why. One, I think it costs the parties a lot of money to do that. And it takes a lot of time. And if you have somebody out of work, I can't think of any reason why I would want to first have a hearing on arbitrability, then maybe get briefs on arbitrability, then have to write about arbitrability, and then say, okay, it's arbitrable, let's start again, let's find dates for arbitration. I'm not a fan. Why do some people like it? Some people fear somebody who thinks they have a great case on arbitrability but a poor case on the merits. Let's say an employer discharges someone and they don't think they really have good cause, but they have a great arbitrability claim. They don't want to have the merits heard at the same time as arbitrability, right? Because they don't want me to think about that. And I would just say this, most of us are sophisticated and experienced enough to bifurcate in our mind. And by that, last comment I'll make, is I always tell folks, I won't bifurcate, but this is what I'll do. I will assess arbitrability without thinking about the merits, and if I find it's not arbitrable, the decision you get will stop right there. Right? Only if I find it's arbitrable will I continue on to the merits of my decision. I'm not a fan. I don't know about you guys. You might have a different view. Oh, I'm sorry, yeah.
Well, I was going to say I agree. Arbitration is supposed to be efficient and cost-effective, and that really negates the whole point of the process to request bifurcation in that way. And sometimes contracts do allow or require bifurcation, depending on what the language says. It might say you have to have arbitrability decided first before the merits proceed, and in that case, we go with what the contract says. But I tend to agree with Marlene on that.
And if you look at these books on arbitrations, you'll see that arbitrators go in different directions on that point. Oftentimes, I'm going to get persuaded by this 11th hour move to say, oh, and it's not arbitrable, when the parties went through an extensive pre-arbitration procedure, and then they get new counsel, and the counsel drops that on the other side at the hearing. I'm inclined to do what Marlene does as well, because if there is no merit to the case, then I don't even have to reach the arbitrability issue.
Katie, you want to move on to?
Sure. So this example is about subcontracting bargaining unit work, and the contract doesn't talk about the subject of subcontracting, but there is a recognition clause that the union could point to. So the first question is, as the advocate for the union, what would you say to the arbitrator to convince them of your argument if you're not pointing to specific subcontracting language? So first and foremost, what is the recognition clause? It's the article of the contract that says what the work is that belongs to that bargaining unit, and it identifies the employees and the jobs, or both, covered by the contract. So depending on that clause itself, the union is laying claim to the work that is done by the bargaining unit, and the advocate would argue that that clause details the nature of our work, and we represent everyone at the employer who does that specific work. You'd have to emphasize how strict that clause is, and you'd also want to demonstrate, if possible, that the subcontracting had an impact on bargaining unit employees. For example, was the purpose of it to replace current employees with these subcontracted workers, and did it erode the bargaining unit? You could look at things like, do the parties have a past practice of subcontracting this work? What was the reason for it? Was it economic based? Was this work done by the bargaining unit frequently, or is it listed in a job description of some of the bargaining unit members? And do these individuals in the bargaining unit have the skills to do the work, and how often is this supposed to be in place as a type of subcontracting? The second question I think we covered on the bifurcation piece, so we can keep going.
Mark, you want to move on to the next?
I will, but I just have one thing to say about that particular situation. We had another subcontracting question slide that we decided to eliminate because it kind of overlapped the same areas, but it highlights how it's not a simple matter. In one scenario, the contract protects the work of a classification, say cashiers at a cafeteria, but says nothing about the food prep people. And the question was, can the employer just subcontract the food prep work? One would think that that might be an easy question. But if you have a history where the food prep people have been the exclusive farm team for the cafeteria's workers becoming cashiers, then you got a question as to, well, does this create a past practice that protects these food prep workers? I don't have an immediate answer to that. Okay. Now, going to subpoenas, and how many people here in representing their constituent have sought out subpoenas or issued subpoenas? Okay. Now, as you know, under AAA rules, subpoenas can be provided by the arbitrator on his or her own volition or through application to the arbitrator for that purpose. In a court of law, oftentimes subpoenas can be sought ex parte, but in an arbitration under AAA, the other side needs to be served with a copy of the subpoena. Now, subpoenas are just that, something to require the witness to come to the arbitration either with or without documentation for the purposes of litigating the arbitration. In this scenario, you have issued a subpoena, the witness sends you an email stating that she wants nothing to do with the case. How do you proceed? You drafted a subpoena for the arbitrator's signature, a document subpoena, for a non-party, which requires production of documents 3 days prior to the hearing. That's the second scenario. The arbitrator in that second scenario refuses to sign the subpoena. I'll get to that. Let's go to the first question. Witness says she does not want to have anything to do with the arbitration. What is your option as a party seeking to get that subpoena honored? Anybody know? Can the arbitrator says, hey, you all better come to this arbitration, I'll come to your house and get you?
Homer could do that. Because he sits on the
Okay. The arbitrator doesn't have that power. That subpoena, if it's not being complied with, would have to be enforced in a court of law. There would have to be a petition filed with a federal court requiring the enforcement of that subpoena. As a practical matter, does the party want to go through those changes? I don't know. It depends on how significant the testimony is. Does the arbitrator have some say in it? The arbitrator oftentimes, and Marlene can tell you better than me, will mediate that difference and bring the parties concerned to the table to find out what is needed and whether or not there are workarounds so that we can proceed. Now, in the second scenario...
Mark, before you go to that second scenario,
okay.
You have the first one that you just indicated. Would you, as the arbitrator, accept the affidavit of the witness who doesn't? The witness says, I don't want to be there. I don't like arbitration. I don't like this. But I'll give you a statement. Would you accept that statement?
As the arbitrator, I would not. I think that unless the witness can demonstrate or there is a compelling reason, health or otherwise, that does not allow that person to be able to be present, the other side has a right to cross-examination. And that right should not be denied through the introduction of an affidavit in place of the witness. If that is all that the party can produce in that regard, we have a tendency to be a little bit reticent about not accepting evidence. I might accept it, but it's probably not going to have a lot of weight.
Katie, Marlene, where would you come out?
I don't know that I would let it. I mean, I would want a darn good reason why there is an affidavit or a statement. As I sit here, I'm on my deathbed, my work. But other than that, I would say no. And one of the scenarios I'm going to talk about touches on that, because one of the most important rights of the parties is to cross-examine the witness. And it is critical that the arbitrator be able to assess credibility. And you just can't really assess a piece of paper. It's hard. So, I tend to agree with Mark. I think there's some times where you just feel, you say, if you feel that strongly, I'll take it, but let me tell you that this will not become outcome determinative for me. It just will not. And if you think it will, you're out of your mind.
Could you go to the mic?
Do I have to?
Well,
How's that?
We can barely see.
Oh, okay, I'll go to the mic. It's a real short one, though.
that's great.
Short is what we do.
Where is it?
Right there. There's one right here.
We just want to make sure that everybody hears you.
Okay, thank you. I'm just curious, if the opposing side didn't disagree with the introduction of a statement, which I'm assuming would be an affidavit, would you still then not accept it? And, assuming you would or wouldn't, would you then turn to the parties and say, look, if you're willing to put in a statement, then just give me a stipulation of facts as to what that person would have testified to. Don't give me the person's statement.
Well, let me just say the following. A stipulation of facts is a creature, okay, by which the parties agree that the contents are accurate and correct, right? And it's a wonderful vehicle sometimes for running an efficient hearing and getting a chronology right, if that's really not what's in dispute. If that's what we're talking about, I have no problem. And it's a good point you're making, because I think what we're presupposing, right, is that the material contained in the proposed affidavit is a matter in dispute. If it's not, then the answer would be, and good idea at arbitration. You could say, I'll tell you what I'll do. I'll take this affidavit, we're going to hand it over to the other side. If you agree that these are the facts, I'll consider it stipulated. I got no problem.
Yeah, but there's another problem. Let's say it's a proffer. If the witness was here, this is what the witness would testify to.
That's it.
And then if the witness says, the witness would testify that it was cloudy and gray and the light was green when they approached the intersection. And your witness, the other side's witnesses are going to say directly the opposite. Then it's not going to be very valuable.
Well, then I'm assuming the other side wouldn't say, we'll agree to that document coming in anyway. Thank you.
Katie, do you have a...
No, I agree with Marlene's point that it's essential to be able to question the individual and have the right to cross-examine the individual in person. Otherwise, what weight do we give the testimony? It's not testimony. It's just a speech that is printed on paper.
Okay, Mark,
Okay. Now, so, second scenario. You drafted for the arbitrator's signature a document subpoena for a non-party witness to produce some documents 3 days prior to the hearing. And the arbitrator says, I'm not signing that. what do you do about that? Is the arbitrator right that the arbitrator says, I don't have the authority to sign such a subpoena?
Anybody got a thought?
How many people say, yes, the arbitrator's right not to sign?
There are no abstentions allowed in here. Take a stand. So how many would say that the arbitrator does not have the authority to sign? Raise your hand. Come on. You're not going to be tested on it.
Okay. I got a good hand.
Okay. All right. Well, the arbitrator does not, in New York State, have the authority to sign a subpoena that is essentially discovery. They want these documents 3 days before the hearing. That's discovery. Section 7 of the FAA. So we're not just talking about New York State. We're talking about the Federal Arbitration Act. That's right. So the arbitrator will say, I'm not signing that subpoena. Does the party have an option if the party wants those documents? Yes, they do. They can correct the subpoena. They can make the subpoena, draft the subpoena to say, a witness, the custodian of the records, has to appear at the arbitration with the documents for the purposes of producing the documents and questioning them on what the documents are. Okay, problem solved, but not really. That means the parties are seeing the subpoena documents, and it could be a document dump, for the first time. Time has to be spent going through these documents. All parties get a chance to do that, to find out whether or not people are just gold digging or whether there's something of substance. There again is where the arbitrator will put on his or her mediator hat and will say, what are you looking for? Is there something there that does that? Let's try to weed through this. Tick, tick, tick. Any perception?
There's one thing I think you should keep in mind, what the subpoena, which is implied by what Mark has said. The arbitrator has the authority to issue a subpoena based upon the law that says that the arbitrator who is going to be hearing the evidence can require the evidence to be produced at the hearing. That's the theory. So that if it's to be produced before the hearing, as Mark has indicated, that is discovery. And unless that's permitted in the collective bargaining agreement, it will not be permitted, and the arbitrator will not sign it. And so I think it's important to keep that notion in mind. Now, the downside of what Mark has said is you got the evidence dump at the hearing. More than likely, there's going to be an adjournment of that hearing if the evidence that's been produced is voluminous enough, because neither party has had an opportunity to look at it. They don't know what is in there. And so now the arbitrator is going to be faced with the question, who pays for that day? I'll leave that one.
Okay.
Arlene?
Not for evidence? Okay. So actually, this next scenario that, okay, good, take a look. This actually follows up on kind of that issue about, you have an affidavit and when will you let it, so when will you let that affidavit in or not? And so I'm going to kind of be a little quicker than I would be because I would have talked about it. But I want to say this about evidence, okay? People get, I talk about this when I teach it, people get so hung up on evidence. Is it admissible? It's not admissible. I say this, arbitrators care about reliability. If you're not a lawyer, or you are a lawyer but you can't think of what objection you want to make, speak to that. For example, the dreaded hearsay rule, the exceptions against hearsay, all of them are predicated on whether the information is reliable, like the old one people teach is, your dying declaration, I did it. You did it, you have your last breath, you tell the truth. So the point is it reliable? That's one thing that's always going to be in play, and the second thing is credibility. So let's just talk about this real quickly because it's important. So you have two witnesses, right, in this case. I'm going to assume they're going to theoretically corroborate each other, right? I'm going to assume for the purposes of this hypothetical that they're testifying about a very material fact. They're not talking about just some, setting the stage, describing the operation of the university. They're really at the heart of the case, okay? And one can't come. The best argument someone would have for trying to admit one of these two statements in lieu of the witness, right, would be to either, I'll give a couple arguments. One would be to say, we've heard the first witness, and the second witness will just be cumulative. It's just piling on. We don't need it. Therefore, you can let it in. I don't love it. The next argument, and the arguments that I think are the best you can do with this situation, is you can say, an employee who gives a written statement during a disciplinary investigation when they're not the subject of the investigation is likely to tell the truth because they put their job at risk if they lie during the investigation. So you, Madam or Sir Arbitrator, should consider that there's some reliability to that kind of statement. By the same token, the statement given at an unemployment compensation hearing, you would say, is it a quasi-judicial kind of proceeding, you're writing under oath, and so we should be able to take that testimony as reliable. Neither of, I should say, having said that those are the best arguments, I don't like them. I don't like that side of the argument. My view of this is, you have two witnesses, whatever side you're on, you want to put them on, you put them on. And if your witness is unavailable that day and can't make the hearing, then you argue to the death about, let's get this person on by phone later in the week, by Zoom later in the week, let's have a half a day, let's do whatever we have to do to hear this witness. Because, Mr. or Ms. Arbitrator, you cannot assess the credibility of this witness unless you hear them. And if I were an advocate, I would push very, very hard on that point. I would be very uncomfortable. I mean, they make a statement during the investigation, but for all you know, they have some bias, right? They're a friend of someone involved in the case. Or they're very fearful of not agreeing with the administration, or so forth and so on. So I would be very, very uncomfortable with those two things. And there's a difference between not being able to make the hearing on that date and being truly unavailable for the foreseeable future. A very, in my opinion, different question. Yeah.
Katie, Mark, do you want to comment on this?
No, I think she covered it.
Yeah, same.
I would add one caveat, and I think I'm not going to go into it now because we're going to talk about a document with regard to the hearsay rule, which I think the panel may differ from me with regard to that. But what Marlene is talking about is a witness testimony and not a document. And there is a distinction to be made, so keep that in mind as we go forward. Mark, you want to take the next one?
Sure. Okay, so we have another evidence scenario. In a contract interpretation case, the union's attorney presenting the case, who has negotiated the contract, decides that she will testify to the bargaining history. And gets up and then sits down in the witness chair and proceeds to give testimony. Now, as the university representative, do you object? How many people would object?
Whether you're a university representative or not, put yourself in that role.
Okay. How party would not. Okay. All right. Well, why wouldn't you object?
Because I think you can document the bargaining history. You can go back and show the previous clauses and what was struck and what was added. I think it's easily able to corroborate.
Okay. So if that's the case, suppose the attorney/witness is testifying to what she believes was agreed to and what was the understanding of the parties when they made that tentative agreement. Wouldn't we have a problem there? The concern the American Bar Association Rule 3.7 has a problem with the lawyer as a witness. Combining the roles of advocate and advisor creates a confusing scenario. Advocate supposed to be able to elicit the evidence from the client and through his or her questioning interpret the significance of it for the trier of fact. If you are an advocate playing witness, then what is your role? Where are you going between explaining objectively what transpired versus saying this is what you experienced? So combining the roles of advocate and witness can prejudice the tribunal and the opposing party, and can also involve a conflict of interest between the lawyer and the client, according to the American Bar Association. The tribunal has a proper objection when the trier of fact may be confused or misled by a lawyer serving as both advocate and witness. So the opposing party should object. Held to the yes. I object. Now, what is the option there? Well, the attorney can bring somebody else from their firm and have that person question the attorney, so the testimony is not in the narrative. I don't think that that's a great solution, but I understand that many arbitrators would accept that. What's your thoughts?
Present company included, and I have done it. The other point I want to make is that what Mark has said applies equally to a non-lawyer in terms of the basis for the objection. In our system of adversary, we don't allow narrative testimony. When I did some training some years back in common law countries that were British, I was astounded by being told, you can't ask the witness questions. That's interference with the witness. You have to ask generally and then let the witness go. Well, that's exactly what you can't do in an adversarial system in the United States. And so I think the problem is solved by someone else other than the advocate asking the advocate questions, so the advocate isn't doing a narrative. It's not the greatest, and it doesn't, but I think in arbitration, I usually permit, and if I know beforehand that the advocate wants to testify, I will make a ruling, you bring somebody else in here to do the questioning.
Let me just add, sometimes this is really hard for arbitrators. Let's say you have you need to construe a contract, and you need to understand how the provision came into being and how it evolved. And the provision came in maybe 2 contracts ago, and the executive board of the union has pretty much turned over. So the lawyer is the same, right? The lawyer's been there and was at the table. And the lawyer has valuable information about what was said at the table, what kinds of examples were given, what was said at the table that led to that language. I have a hard time not letting that lawyer testify, but I'm a little, once they sit in that witness stand, they are not going to finish that case before me. There's going to be another lawyer. It could be from the same firm. But I have this really difficult idea about how am I going to assess the credibility of that lawyer who's at the same time arguing with me about the credibility of the other witnesses. Is he going to argue about how credible he is too? I mean, so I say go ahead. If you need to sit in that chair, you sit in that chair. But take an hour, take 2 hours, take 2 hours, adjourn. I don't care. Come back and bring another lawyer to finish the case and you can testify about bargaining history. You've been transformed into a witness. That's the end of you in that point. But, you know, it depends, but it can be very, very tough. I think the one thing, Homer, and I tend to agree on is, it's hard to say no under certain circumstances because you could really be depriving one side or the other of the kind of valuable bargaining history or practice information that's essential to making the right call.
So if I understand what you're saying is that once you're designated a designated hitter, you can't go back.
I made that rule. You know, I don't want you to say, Mark's the one who say rule 740. I say Marlene says, but no.
Now I forgot what I was going to say.
We stopped doing that. Okay.
I just wanted to add one point that, to me, it would be a very unusual situation where this attorney did not foresee that they would now have to sit in the chair as a witness. If they're doing a very thorough preparation of their case, they would know this well before the day of the hearing and could plan ahead and have another attorney handle it. So proper preparation could mitigate
People
them.
insist sometimes on being unprepared, you know, they do.
But Kate is right. In most of the instances in which I have faced, I have been told beforehand that this is going to happen, and I make the ruling, and so they know exactly how they're going to proceed. And what I don't go as far as Marlene and say you're out. Once up, you're out.
But to Katie's point, I think it would be fair, and it shouldn't be surprising to the parties, for an arbitrator to say, whoa, how did we get here now without me hearing a word about this? And that's a really good point, Katie, because, you know, some problems in arbitration are unavoidable. Others, the parties bring on themselves. No? And that's what the point is.
And I think the point here is that the arbitrator is always looking out to make certain that there's no ambushing going on. And that sounds like an ambush to me. Katie?
Can you do the next slide, please?
Great.
Thank you. So this example is about an employee's discharge for a positive drug test. The person appeared to be under the influence at work, and they complete a rehabilitation program after they're discharged. How valuable is that evidence of the rehabilitation, and would it be considered as relevant to the case by the arbitrator? So in this instance, the rehab occurred after the university made its decision to discharge this individual. So evidence of rehabilitation could be viewed differently depending on what that individual did as their job. In some university settings, employees might hold a commercial driver's license, and the testing for drugs and alcohol is very specific under regulations. And in different safety-sensitive jobs, the parties might have negotiated procedures for a drug testing policy with a 1 or 2 strike rule, or might say rehabilitation could mitigate the penalty or be part of the party's process for a return to work. But in this example, as it's written, I would only look at whether there was just cause for the discharge based on all the different events that happened up to the day of the discharge itself, not what happened after. But if I were to look at all of that and say there was not just cause for the termination itself, I might look at that rehabilitation and later conduct to decide is there some sort of mitigation or a lesser penalty that is warranted based on the facts of the case. The union would want to look at and prove this person was troubled, and that's why there was a substance issue. The trouble was directly related to the issue that occurred at work, and the rehabilitation, quote, cured or fixed the trouble, and it's not going to happen again kind of argument. But rehab also would not be considered in a vacuum. It'd be looked at with all the other mitigating circumstances arbitrators normally look at. How long has the person worked there? What's their performance record like? What's their prior disciplinary history? Any other issues with drugs or alcohol at work? So it's not looked at in a vacuum, but it would only be looked at as far as that mitigating factor Anything after the discharge goes into that bucket. The just cause is looked at for all of the things that happened up to the date of the discharge.
I want to emphasize something that Katie just said that is very important. The just cause inquiry is twofold, and they should be kept distinct. The first question the arbitrator has to answer, was there just cause to discipline the employee in the first place? And then obviously to discharge if that was it. Was there a reason, is the arbitrator persuaded that there was a cause for the discharge? And let me say here, for those of you who are new, don't argue the 7 tests to us. Please, I beg you, don't argue it. We're going to not...
Argue what?
The 7 tests of just cause. Has everybody heard of the 7 tests of just cause?
No. Yes, then forget it. Never let it cross through.
There was an article written years and years ago, and it was in the railroad industry, in which the discipline is done in an appellate level, and the writer Doherty outlined 7 tests for determining just cause, and concluded by saying, unless the arbitrator finds that all 7 tests were met, then the discipline can't stand. Well, there's no arbitrator that I know of who's still working who's going to do that. Take, for example, an employee and a supervisor get into a verbal altercation. Or no, I'm going to make it even more simple. The employee and the supervisor are talking, and all of a sudden the employee hits the supervisor in the nose. And the supervisor says, "You're suspended." And the employer subsequently discharges the employee. And there is no indication that there was any provocation from the supervisor. And the union argues there wasn't proper discipline before we suspended him. Well, he hit him. And there was no indication that there was any provocation in that. That's an example of, okay, was there notice that you shouldn't hit the supervisor? Was there all of the, and the other 7? Those are not going to be considered by most arbitrators. Their arbitrators are going to consider those factors that are relevant to that fact pattern. The other thing that is important that I want to keep in mind that Katie was pointing out is that there are some things that go to the just cause for the discipline, and as Katie pointed out, just cause for the penalty is a separate inquiry. And that's why you can look at mitigation, you can look at rehabilitation. That goes to the question of the remedy. And so you want to keep those distinct from one another. All right. We're going to move through the next couple of things very quickly. The direct examination. One of the things that's very important is to outline your examination. Don't write each and every question. You want to prepare your witness, make sure your witness knows where you're going, but you're not trying to get the witness to remember everything that you're going to be doing. Remember that the witness is the star. Use short, precise questions, and here's the most important. No leading questions. What is a leading question? A leading question is a question in which the answer is in the question. You saw him turn right at that time, did you not? Is a leading question. That is not permitted.
You found his attitude disgusting.
Those are leading questions. They are not permitted on direct. Think about the questions that you're going to ask beforehand and try to avoid objectionable questions. As an arbitrator, I can say for myself that the more objectionable questions you ask as an advocate, the more frustrated I get with what you're doing. And it gets much more difficult to follow you. So get the flaws and weaknesses out on direct examination. If you know that there is a weakness in your case, better for you to bring it up during direct than for it to be brought up on cross with the implications you were trying to hide it. With regard to cross-examination, you want to be brief. When I teach advocates about cross-examination, what I say to them is, think of 3 to no more than 5 things that you want to close with from this witness. You may not have 5, you may only have 3. That's what you want to cross-examine on. Do not make the mistake of going through the entire direct examination so that if I miss something on direct, I'm going to pick it up on your cross. You don't want to do that. Here, nothing but leading questions. So it's okay now to say, but you did see him turn right at that time, didn't you? That's exactly what you want to keep the questions to a yes-no answer. Don't ask questions you don't know the answer to. Don't argue with the witness. The witness has said it, okay, you'll deal with it in your brief, you'll deal with it in your closing argument. Don't let the witness repeat or explain. If you ask a non-leading question, the arbitrator is going to permit the witness to finish the answer. That's why you stay with leading questions, so that the answer has to be yes or no. And an arbitrator will enforce that. Listen to the witness's answers. Far too often, new advocates are so intent on what they're asking, they don't hear, oh, I got what I wanted. Move on. I don't need to ask this next question. And then the last point is encompassed. Then stop when you've made your point. Okay. Closing arguments. Marlene.
Okay. I'm
Go. Sorry.
Let me just say that in my practice, I think it's pretty common. In lots of discipline cases, unless it's a very, very fact-rich, very difficult factual scenario, I generally don't get written closing arguments, but I very often get them in contract interpretation cases, cases of past practice, and contracts where the language is not clear and needs to be construed by the arbitrator. So that's sort of how my practice breaks down. Homer explained, in the opening, I can't say it enough. We walk in the room, we don't know anything about the case. If we've got the case from the American Arbitration Association, we have a letter appointing us, and it might say discharge of a home rule rule, it might say violation of various contract provisions. We know almost nothing about the case. Your opening is our first exposure to that, right? And so you're free to say there's several arguments that support our position. Maybe they're not all good, but there's several, and here's some of them. But when you get to closing, there's 3 things you need to do. And my advice to you is, if you can take a few minutes and do it orally, but if you're not comfortable and you need time to prepare, you ask to close with a written closing. The 3 things you need to do is you need to whittle down all the arguments you made in your opening and focus on the strongest points you have. And that might have changed because now you've heard all the witnesses. And that witness you thought was going to be so great for you got really nervous and didn't really help you out so much. Or maybe the company came through with a witness who you didn't think had seen much, but turns out was a great witness. So you need to whittle down your arguments and focus on the strongest arguments you have, okay? Then you take those arguments and you marshal the facts, the record evidence. You pull from the documents and the testimony in your closing brief or argument what supports your position. So if you say, the witness couldn't have seen that, and we've always said that, you say, and indeed, this person said that they were 100 yards away and were talking to someone at the time and didn't see the whole incident. The other person really, turns out, only arrived at the scene halfway through the incident, so forth and so on. So you take your arguments, you connect the record evidence to it, right? And then you rebut the other side's argument. You say, and to the extent that the other side will claim A, B, C, those arguments should not prevail. That is essentially what I view as a really good closing. Here are some tips, okay? Don't just repeat everything you said on opening. We heard you. We want to know what you think now, okay? And oftentimes I hear openings and I go, wow, that's a pretty serious matter. And by the end of the hearing I'm going, no, not really. So again, don't repeat your opening. Don't do that, okay? If you're submitting a written brief, please don't give us paragraph-long string citations for principles we understand. Don't tell me that many arbitrators consider a discharge the capital punishment of discipline. No kidding. No kidding. And telling that to me with a string cite this long doesn't really mean anything. I'm into turning the page. That's what I'm doing. So you can state something, you can cite a case if you want. What I look for are cases that are on point, that have very much to do with your fact pattern and have very good language that pertains to your case. And those few cases are the cases you want to cite. And I, for one, appreciate very much people providing an actual copy of their case. I don't know, but I have so many clients who seem to think that I spend my nights and weekends researching these sites, trying to pull up the case and see if it was appealed. No, no. You want us to focus on it, give it to us. That's your right. Take advantage of it. Quote that award if you like, or court decision. But don't overly do it. Stick with the ones that really, really make your case for you. And I think that's really important. And my last thing I want to say about discipline cases and closings. The three things that I think are so critically important in every discipline case is assessment of credibility, okay? The context in which the misconduct arose. For example, I think you heard I came out of the sanitation department. So we have lots of jobs. If you don't show up one day and the weather's inclement and you're no show or no call, you might get suspended for a day, you get a warning. It's sanitation. If it's a snow day and you don't show up, bye. So the point I'm making is context can be everything. It's so important, and it works both ways. Oh, you cursed and said horrible things, and is the context that everyone sits around at lunch and does that? Let me know. Context, right? Consistent and credibility. And the last one, which I'll talk about a little more when we get to penalty, is consistency. So there you have it.
To add one more thing, the decision about whether to use a written closing or an oral closing is somewhat regional. Marlene has indicated that her practices. In my practice, DC and around the nation, I almost always ask for written closings. I think they're better, that they're more thoughtful. All the things that Marlene has pointed out are better put together in a written closing than they are in the few minutes that the parties may take to do an oral closing. The other point...
I have a question on that. Is that written closing in your situation in lieu of a brief or in addition to?
Oh, no, I'm sorry. I'm using written closing. It's the same thing as a written brief. Some people call it closing statements, some call them memos, some call it a brief. They're all the same. It's just in writing. The other thing is that, from Marlene's point about citing cases, I require now that parties, if they're going to cite a case, give me the hard copy. I'm not going to go looking for it. All right.
We have a few more minutes left. I think we'll make it. Mark? No, Kate.
Post-hearing issues.
Let me get it up.
Okay, so this example is about after the hearing actually closes, the person who testified goes, aha, I found those bargaining notes I didn't bring to the hearing that I testified, all about the negotiations. I really want to reopen the record. Can I do it? So there has to be finality to the hearing process, and once the record is closed, it's closed. If one party requests to reopen the record after it's closed and the other party says, I don't agree to that, I disagree and I object, I would not reopen the record. The moving party has an extremely high burden to show there should be any consideration for reopening, and they have to show this is newly discovered evidence that could not possibly have been discovered and brought to the hearing itself. From this example, it's not clear to me why this witness only miraculously found the notes well after the fact. The person knew what their testimony was going to be about and probably knew it might be helpful if I have these notes and bring them along. And if the witness wasn't adequately testified to their recollection of what happened at the table, and the other party did not say, hey, where are those notes you said you took? That's another reason not to remotely consider reopening the record. And then if another party introduces evidence after the fact, as we've already said, the other party won't have a chance to refute that evidence or cross-examine the person about what they're trying to provide. So I would very rarely, if ever, reopen a record. I imagine many of you feel the same way.
I completely agree. The closure is closure. Marlene?
Yeah.
Yes.
I'm next, yeah?
Yes.
Okay, so this is sort of, let me just say this. I think we all agree at this table that finality is one of the reasons people have an arbitration problem. So there is really no finality if everybody gets to say, wait, I found one more thing, I have one more thing. And the other side says, well, okay, well, I got something now, okay. So, this is why people, in some sense, go to arbitration, because they want an efficient vehicle for getting an answer. They want it to end, and they want the dispute to end. Anyway, it's to this point about they call you late in the day and realize they made an honest mistake on dates. Let me say this, folks. I have lots of clients, I'm on panels where the advocates on both sides know each other very well and don't get along, and I have other panels where they know each other very well and get along. And it's embarrassing when someone makes an honest mistake about dates. If you have a relationship, here's my lecture in a nutshell. Everybody messes up sometimes, okay? You can be a real difficult person if someone calls and says, I'd like to go to the arbitrator and clean up this record and make clear up this mistake. And you can say, no, you have no right to, finality, But the next Tuesday, when you make a mistake and you gotta call that guy, that person's gonna say, what? So my suggestion is, in the world of labor relations, if it's not a date that is gonna rock the case and change the outcome, you pick up the phone, you call the other side, and you say, look, I have a situation. It was inadvertent. The person feels horrible about it. They could get fired, whatever. Can we please just call the arbitrator and ask her to create, to let us correct the record? And if there's a mutual request, I can't imagine we wouldn't do it. But this is a pitch on my part to say, not everything has to be so adversarial. And sometimes when you can agree to be professional and respectful in the times when mistakes are made, it goes a long way. It really does.
Okay, Katie? Did an arbitrator retain jurisdiction?
Yes, in limited circumstances. So the Code of Professional Responsibilities for Arbitrators specifically says an arbitrator can retain jurisdiction over the remedy in order to resolve any questions that may arise after the award is issued over what that remedy should be. But that does not extend to any other parts of the award itself. It's only about the remedy. So if the remedy includes something like back pay, in my awards, I would retain jurisdiction and write that into the actual award itself over the issue of remedy for a specific period of time, such as 60 or 90 days.
Great. Mark, you want to take the research assistant scenario?
Oh, yeah. So, well, it was probably that same research, same employee that got fired for taking drugs on the second job. So he came back and he's working as a research assistant, working for a grant from a nuclear energy commission in a safety-sensitive job. Griebel was discharged for being under the influence and was reinstated through arbitration. Management thinks that the employee is still using drugs and does not want the employee back. Does the university have the obligation to reinstate the grievance? Can it take any steps to prevent the grievance return? The major thing to consider in this scenario is, what is the management basing its thought on? Management thinks, is this speculation? If so, management isn't going to go anywhere, certainly with the arbitrator who has already ruled, and not going anywhere with the court in trying to reverse the arbitrator's award. The grievance was discharged for being under the influence, and the just cause wasn't established, then there's no second bite of the apple. Now, if the circumstance was stronger, if there was a compelling demonstration that this person was a continued user, well, and because of public policy concerns that this person is in a critical, sensitive position, maybe there's a better argument. But those situations are extremely rare. I refer to you the W.R. Grace versus rubber workers in the Supreme Court, which talks about that unless it can be shown through public policy exceptions that involve federally mandated testing, courts have would vacate an arbitration award rarely unless it violated the specific statute or the spirit of that statute.
Okay, we're running out of time, so I'm going to leave, just say, I'm going to take Marlene's last one, and in terms of reinstatement without back pay, rarely, I think arbitrators are kind of all over the place. Some do, some don't. My rule is I'm going to consider what's appropriate to the penalty, to the wrong that's been done, and the back pay is going to be geared to that. I don't simply say no reinstatement under all circumstances.
I agree. Can I add one thing?
Yeah,
I just want to add one thing about penalty. This is my advice to both sides. Don't leave us, arbitrators, to decide what the penalty is in a vacuum. Don't do that. What you want to do, and it's just an important tip, is we need to be educated by the advocate, right, as to how this misconduct's been treated at that workplace by that employer, right? So you can, one side can convince me that normally termination would be appropriate, but if the other side shows me that in the last 5 years nobody's been terminated for that, it's going to be a different outcome. So I would suggest that when you think about the penalty you're asking for and the penalty you're objecting to, you put it in the context of what has been done at this workplace and how consistently. That's great.
Yes.
First of all, I want to thank you for the work you do. It's very important in this, the tense situations and all that. So thank you for that. There was a phrase that kept on being talked about, and I wonder if you could maybe separately, or past practice is such a slippery thing. And I know there are different levels of it and all that kind of stuff, but as a union president, Tony Cruz, by the way, from SUNY Orange in upstate New York, suppose there was, let's say, a former president of a union that kind of had some backdoor deals where the union kind of overlooked some things that were going on. And I'm not saying this happened, it's just it's a scenario. And then a new administration for the union comes in and sees that this is not right, and maybe it's not so clear in the contract, but it's certainly gleaned them some benefits in their careers before. Can some of you speak to issues of where there was past practice and it was slippery and you had to make it important or difficult
Use the
decisions?
prerogative as the moderator and say that that can't be answered in 3 minutes, but
Good email me then.
there is, past practice is basically, it has to be consistent with the collective bargaining agreement. It has to be something that both parties have acquiesced to over time. And there's an excellent article that was written years ago, and Richard Mittenthal, on past practice. And it is still the word, the Bible, on past practice and how it should be applied. If you Google it, you will find it very easily, and I highly recommend it to you and to everyone. It's still the best thing on past practice.
Thank you.
Thank you. Richard Mittenthal, Mittenthal. One last question.
Hey, my name's Tanisha with the Harvard Graduate Students Union. I have a question about continuing violations. I know they're kind of like hit or miss. Some arbitrators grant them, or like say that something that's a contract violation can be viewed as a continuing violation, but others don't. And so I'm just kind of wondering about what best practices would be for arguing that a contract violation is a continuing violation.
Well, what I'm hearing is that how does an arbitrator treat a continuing violation?
Yeah.
When it just keeps happening?
Yeah.
If the arbitrator is presented with what is the basis of the agreement, if the party demonstrates that that activity has been ongoing and the union has been pushing back at it, whatever the finding the arbitrator makes regarding that will go towards the remedy. If after the arbitration is decided and that violation continues to happen, then we have a question as to whether or not the employer is abrogating the contract by not following the arbitration provision and the award.
But then that means perhaps if the arbitrator has ruled on whether that there is a violation and has ordered the employer to do whatever is appropriate, and the employer does it again, it's a new violation, that same arbitrator is not going to hear it. The arbitrator only has jurisdiction over the case that has appeared. Now you've got a new grievance.
This comes up a lot in sort of inappropriate calculation of payroll. And so, you know, the argument is every 2 weeks there's a violation, right? And so the way a lot of us look at that is it is you could call it continuing, I call it a recurring violation, right? And the question really is not so much, is it a violation? It is, if it's not, doesn't comport with the contract. The question is, how far back do you go for the relief? That's which we don't have enough time to talk about, but that's the tricky part. So if someone doesn't complain for 2 years and every paycheck they're improperly paid, and then they wake up and say, I'm filing the grievance, the question is, how far back should that arbitrator go, right? And sometimes we're guided by the contract that says things like you have to file the minute you realize or within 30 days, and then we get some guidance from other language in the contract. But that's what leads to my mind is a very common continuing violation scenario.
Yeah, often the continuing violation argument is one that allows the grievance that would have been time barred not to be time barred. But as Marlene points out, but your remedy isn't going back 3 years if you haven't complained.
But it can go back 6 months if it's an unfair labor practice and you decide to file a charge.
Thank you, Mr. Chairman. With that, I want to thank the panel for the presentation today and for your